Hello friends, this is JAWWAD KAZI and I'll be discussing some important topics of current affairs which are relevant for UPSC examination. And the first such topic I intend to take up is the debate around abortion laws in the country. In recent times, if you've been reading the newspapers, you'll be aware that there is a debate that is going on around abortion laws in the country. And the trigger for this particular debate was a recent Supreme Court judgment where the Supreme Court allowed a woman who was well beyond her 20th week of pregnancy to go for an abortion. Okay, and the grounds of this permission was that the fetus was having some severe abnormalities. Now, as per the Medical Termination of Pregnancy Act 1971, a woman cannot go for abortion beyond 20th week of her pregnancy on the grounds of fetal abnormalities. Okay, only in the case of severe risk to her life can the abortion be performed, and not on the grounds of fetal abnormality. But considering this particular case as a special case, the Supreme Court allowed this woman, who in her plea had stated that she was allegedly raped under pretext of marriage, and gave her the permission to go ahead with abortion. Friends, in recent times, several such judgments have come from different high courts of the country, and the recent Delhi High Court judgment also can be stated as a case in point. So that brings the entire issue of liberalization of abortion laws in the country in the national discourse. And before I get into the technicalities of that issue, I would briefly like to draw your attention to some important statistics over here. Worldwide, friends, it is believed that 46 million women go for abortion every year, and half of these abortions happen in unsafe conditions. Okay, and in developing countries, whether it's in Africa, Latin America, West Asia, Southeast Asia, in all these countries, there are varying levels of restrictions that are there on abortions, and consequently the access to legal and safe abortions is restricted, and that is why women are compelled to go for unsafe abortions, resulting in the statistics say that a woman dies every 2 hours because of these unsafe abortions. If we see the case of India, as many as 20 million women exercise this option of abortion every year. So that's a huge and startling number that we have in the country. And although the Medical Termination of Pregnancy Act has liberalized the access to abortion, but nevertheless it has not been able to ensure safe abortion services. Okay, so because of that also illegal abortions and consequent mortality rates are relatively high in the country as well. Now let us get into some backdrop of this particular issue. As per the Indian Penal Code, section 312, abortion, that is causing of miscarriage, the official term that the Indian Penal Code uses for it, is considered to be a criminal offense. Okay, so doing an abortion or causing a miscarriage is considered a criminal offense as per section 312 of the IPC. Well, one must also note that there is an exception, and the exception is that if the doctor conducts or executes an abortion in good faith to save the life of the woman, then in that case it will not be considered as a criminal case. Otherwise, it is considered as a criminal offense, and it falls in the category of offenses affecting the human body. Okay, section 312 falls in that particular category. Now, after India became independent, during the initial years of the nascent nation state, the Indian Penal Code was actually the overarching rule that ruled as far as abortions were concerned, and consequently the access to abortions was not there for women. Okay, but women are compelled for various reasons, whether it is for rape, whether it is for family planning, for several reasons to go for abortions, and that is why the level of illegal abortions in the country was pretty high. And naturally, these abortions were taking place in unsafe conditions by untrained people, and consequently there was a very high rate of mortality of pregnant women because of these illegal abortions. Now, realizing that, and as well as the important goal of health and family planning, the government felt that there is a need to liberalize the abortion laws in the country, and in that regard a committee was set up by the name Shantilal Committee to look into the matter at greater depths. The committee came out with its recommendations and advised a liberalization of abortion-related laws. And in lines of the recommendations of the committee, the medical terminations of pregnancy bill was presented, and it was passed as an act in the year 1971. Now, what exactly did this MTP Act 1971 do? MTP Act actually legitimized abortions in the country as a health and family planning measure. Okay, now how exactly it did that? It actually gave a set of limitations in which a person or a lady could go for abortion. Now, what were these set of limitations or conditions? It gave, first of all, the circumstances where abortion was permissible. Okay, in what circumstances exactly a woman could go for an abortion were crystal clear, in a crystal clear manner, laid out as per the MTP Act 1971. Then it also gave the persons who are competent to perform the procedure or execute the operation, and thirdly, the place where abortions could be executed. Friends, at this point, it is significant to note that the Medical Termination of Pregnancy Act 1971 happened before the Roe versus Wade case of America. Now, this is a very landmark case in America where the Supreme Court of America ruled in favor of liberalization of abortion laws in the country. Before that, America also had severe restrictions that curtailed the access of women to safe abortions, and in this case, Supreme Court of USA ruled in favor of further liberalization, and consequently several states of America then passed their respective acts to further liberalize access to abortion. Now, what is significant over here is not only did India have its liberalization before America did, but also our liberalization came from a legislative measure, not a judicial pronouncement as in case of USA. Now, apart from these limitations that the MTP Act gives, or beyond the boundary of this MTP Act, the Indian Penal Code is still applicable. Okay, so if abortion violates the framework given by the MTP Act, then the Indian Penal Code is still applicable and an abortion will be considered as a criminal offense. Okay. What exactly are the conditions that this particular act gives? The MTP Act gives certain timelines and corresponding authorities who can in certain circumstances allow a woman to go for abortion. Okay, so what are these timelines? The first one is that of 12 weeks. Okay, up to 12 weeks a medical practitioner can approve a woman to go for an abortion. Okay, up to 12 weeks of her pregnancy, a single medical practitioner can do that. But if the pregnancy advances beyond 12 weeks, then up to 20 weeks a medical board can do that. Okay, so a medical practitioner up to 12 weeks and a medical board up to 20 weeks. But friends, it is not that the woman has complete freedom of choice as to when she can go for an abortion. Here also, while ruling, the medical practitioner and medical board will allow it only in case of two circumstances. Okay, the two circumstances are that if the continuance of the pregnancy would involve a risk to the life of the pregnant woman, or first of all a risk to her life, or of a grave injury, whether physical or mental health. Okay, in that case the medical practitioner or medical board can advise a woman to go for an abortion. And physical or mental health also includes rape. Okay, so a rape victim can on that basis go for an abortion if the medical practitioner and medical board advise accordingly. Okay, this is the first condition that limits the freedom of choice. The second is that there is a substantial risk that if the child was born, then he will have such very severe physical or mental abnormalities so as to make that particular child very seriously handicapped. In that case, again, the medical practitioner or the board can advise abortion to that pregnant woman. Now, the difficulty with this particular provision is that although it allows fetal abnormalities to be a grounds for abortion, but it allows only up to 20 weeks. Okay, so the doctor or medical practitioner or the board can advise it up to 20 weeks only. But the difficulty here is that most of these fetal abnormalities are detected during the 18th to 20th week of her pregnancy. Okay, so the doctors as well as the pregnant woman, the medical practitioners have a very short window to decide whether abortion should be done or no, and in that particular short window it is difficult for even the medical practitioners or the woman and her family to take a rational decision whether she should go for it. The next important thing that we have to understand here is that what if the pregnancy advances beyond 20 weeks and an abortion is required? Okay, in that case it will be considered to be legal if a registered medical practitioner in good faith thinks that the emergency termination is necessary to save a pregnant woman's life. Okay, so beyond 20 weeks also abortion is permissible if the medical practitioner feels that there is an emergency and we need to abort the child only to save the woman, save the life of the pregnant woman. In that case, beyond 20 weeks also it is allowed. Okay, but it does not deal with abortion beyond 20 weeks in case of abnormalities in the fetus. Okay, so it is only for the life of the woman that it can be done. Now you might be wondering, what is the rationale behind this cutoff, or you can say the timeline of 20 weeks. Okay, now one important thing that one has to understand over here is that having this timeline of 20 weeks is significant because again around the 18th to 20th week it is possible medically to know what is the gender of the fetus. Okay, and in a country like ours which has a very strong patriarchal setup and the craving for a male child is very high, resulting in adverse sex ratio all over the country, particularly strong in certain northwestern parts or northwestern states of the country, the 20 weeks guideline is significant to prevent adverse sex selection happening in the country. Okay, so if the timeline permits beyond 20 weeks, it may facilitate adverse sex selection where female feticide can get increased. That is a first important point. The second thing is what is called as eugenics, the threat that by allowing pregnancies beyond 20 weeks it can give a fillip to this idea of eugenics. Now eugenics means means good and genics means birth. So eugenics is a concept where you desire only perfect babies, and if we allow pregnancies to go beyond 20 weeks, then there is a possibility that people will only desire babies with all the perfect attributes, and it will become a grounds for people to abort even for small problems that the fetus might be having. So these are the two concerns. One is adverse sex selection and eugenics that lie ahead of us if we allow pregnancies to be aborted beyond 20 weeks. Now, what is the rationale behind the 20 weeks? Okay, in medical parlance, it is believed that the fetus has life after the 20th week of pregnancy. Okay, as far as religion, morals, dharma, ethics, all these things are concerned, yes, the fetus has life as as early as the conception. But in terms of medical parlance, after the 20 weeks of pregnancy are completed, the fetus is supposed to have life. And that is why when abortion takes place beyond the 20th week, in medical terms we are taking a life, and which obviously all said and done should not be facilitated as such. Okay, so that is why the act has a deadline of 20 weeks. Now let us see what are the debates regarding liberalization of abortion related laws. Now the first thing, as I told you, that deformities are detected in the 18th week, around 18th week and further, and that is why the small window up to 20 weeks is not sufficient for the doctors and family to take a rational decision. The second reason is there is a rising trend of sex related crimes, and because of this rising sex related crimes, it is important that the woman has the right to choice to go for abortion whenever such traumatic episode happens with her, and so that her privacy is maintained and it becomes easier for her to have access to safe abortion. The third reason that is cited is that every woman has the right on her body, she has the right to choice and personal liberty also. So she must have, since the woman is going to bear the child, she must have the complete choice whether she wants to or no, and it will also guard her privacy as such. Then the changing values of a modern society. 1971, when the MTP Act was passed, a lot of water has flown down the bridge, and the society has changed tremendously. To cite some examples, now live-in relationships are not a big deal in metro areas. Even the Supreme Court has recognized them in some of the judgments, and that is why, since the society is changing, the values are also changing, and consequently the acts also have to reflect the changes in the values of the society. The next important reason is that in any case illegal abortions are very common. Okay, that for not only have an adverse impact on sex ratio, but they are also exposing women to the hazard of mortality. So if illegal abortions are happening, it will be much more logical to further liberalize so that women will have access to safe abortions. And as per human rights laws, a woman has complete right to choice, a right on her body, and a right to privacy also. Okay, and the restrictions on abortions go against these basic human rights related laws. Then the Article 21 of our Constitution also permits a right to privacy, and that is why also abortion must be allowed so that the privacy of the woman can be maintained. The next reason is that in any case, sex selection has happened in the country illegally, although we have a pretty strong law, which is the PCPNDT Act. But despite this particular act, the implementation of that act has many flaws, and because of it we are seeing that adverse sex selection has happened rampantly in the country. But considering that as a case in point against liberalization it violates the right of the pregnant woman. If sex selection is happening illegally, then it is the responsibility of the state to enforce the PCPNDT Act and ensure that adverse sex selection does not happen. It should not be the owners should not lie fairly and squarely on the pregnant woman that because sex selection are happening, she cannot exercise her right to choice. Okay. The next important reason is abortion becomes inevitable in some difficult situations. Okay, there can be some compelling situations where, although it is very difficult to go for abortion, the woman has to, she has no other choice but to go for abortion. For example, it may result out of non-consensual sex. It may result out of failure of contraceptives. It may result, the family might be going through some financial issues, and in the interest of the first child, it might be necessary for the family to abort the second fetus so that the first child gets the best, upbringing. And also in certain cases where the fetus is having very severe abnormalities, it is difficult for a middle class or lower middle class family at times to bring up such a child, and in that case the support that is provided by the state is also very minimal, and that is why if a couple feels that it is not feasible for them, then they are compelled to go for abortion on those grounds also. The next reason is that a fetus does not have human rights as such as per law. Now this is a technical interpretation. Human rights are vested in a person when he takes birth. Okay, so birth is that event which vests human rights in a baby, and by inference before that the fetus as such does not have human rights, and that is why the grounds of rights of the fetus cannot be invoked against the liberalization of abortion related laws. Now the other side of the debate is the arguments against liberalizing of abortion laws in the country, and the arguments that are generally cited are obviously, which I told you first, is sex selection. It will give a boost to adverse sex selection in the country. It will further give credence to the idea of eugenics. And the third thing is that life is something precious. Only God can create life, and human beings, and especially state, should not allow the life to be taken away at least easily. The third thing is the right of the fetus also. The fetus is one fetus is one of the most you can say disempowered being on the earth, which cannot stand up for its right, and that is why we as a civilized society must protect its right. Next, by allowing abortions, we are also we are also dehumanizing this sacred thing of procreation. It also hurts the right of the differently abled people. Now, over the several years, we have campaigned for a society which is more inclusive of the differently abled people, and that is why we have the Persons with Disabilities Act, and we also instead of calling people handicapped, we use the word differently abled, okay, to underline the fact to the society that they may not be conventional like other people, but they can contribute in their own different way. The recent recent renaming as a Divyang instead of Viklang is also a similar case in point. But if we allow abortions on such grounds of abnormalities, then it sends a message to the society that differently abled people are less valued in the society, and that is why we want a baby which is ideal, whatever definition of ideal one may have, and these people are not welcome. So that is going to hurt the rights of differently abled people also. Further, it will also increase the stereotyping in the society, as in this particular type of features are what are considered as perfect, and any deviation from that is not considered as perfect as such. So that will also be harmful in the interest of the society. Friends, in the year 2008-9, an important case happened in the country, and this particular case is famous as the Nikita Mehta case. In this particular case of Nikita Mehta, this lady was in some 25th week of her pregnancy, and the fetus was reportedly having some very severe abnormalities in its heart, and the couple approached the High Court for the permission of abortion on this particular ground, that is fetal abnormalities. Their plea was since Section 5 of the MTP Act allows abortion on the grounds of severe threat to the life of the woman, it must also be interpreted for the threat to the life of the fetus also. But although the the panel of judges empathized with Nikita Mehta's case, they clearly said that that would be usurping the role of legislature, and they could not reinterpret the law as such because it goes against the what the legislature had visualized as such. Although the case went against Nikita Mehta and her husband, but it created a furor, okay, in a national discourse, and there was a demand for liberalizing our abortion-related laws, and consequently, an amendment was proposed, and these amendments were presented in the Parliament as the MTP Act 2014 Amendment Bill, and this particular amendment bill liberalizes the abortion-related laws further. Now, what exactly does it do? First of all, the timeline of 20 weeks, okay, that cut-off date that we had seen is liberalized now, if the act is passed, of course, to 24 weeks. Okay, so up to 24 weeks, a woman can go for abortion subject to certain conditions. Okay, within this, up to 12 weeks, the woman has a right to choice. Okay, it is not on the grounds of what the medical practitioner says, but on her wish and will. If she wants to go for an abortion, then in that case, up to 12 weeks, she can do the same. Now, this is very significant because of teen pregnancies or rape cases or unwanted pregnancies, failure of contraceptives, and all these things. The woman will now have the right to choice of going for an abortion. So her privacy will be ensured, and the decision making will be faster and easier. Okay, but what if the pregnancy advances beyond that? Now, in this particular amendment bill, up to 24 weeks, the same procedures as in the Act of 1971 will be applicable. Okay, so from 12 weeks to 24 weeks, the medical board can allow or advise an abortion if it feels that there is a severe threat to the life of the woman or her health, or if the fetus is having severe abnormalities. Now, because of this guideline of 24 weeks, now if the abnormality is detected in the 18th or 19th week, still the pregnant woman and her family will have sufficient time to take a rational decision as such. What if the pregnancy goes beyond 24 weeks? Okay, If the pregnancy goes beyond 24 weeks, then even in that case, apart from the threat to life of the woman, even in that case, it will be allowed for abnormal deformities. So that is a significant provision that this particular amendment bill has. Further, unlike the original MTP Act of 1971, this particular act recognizes single sexually active mothers. Okay, the modern society is changing rapidly. Okay, and in it is a reflection of that only that we see over here, where the single sexually active mothers are also considered within the ambit of this particular act. In the earlier act of 1971, it was only married women who were considered. Okay, single sexually active women were not considered in the ambit of the original act. That has to change now. Next, it will allow Ayush practitioners, Ayurveda, Unani, Siddha and Homeopathy, which are other parallel streams of medicine apart from the allopathy that we know, and these practitioners will also be allowed to execute abortions. And there will be a detailed procedure and how exactly it is to be done. It will not be on traditional aspects, but how in modern and safe manner it can be executed. These people will also be allowed. The reason obviously behind that is to allow greater access to pregnant women for abortions. Okay, so this sums up the entire issue of the debate that surrounds our abortion laws. Hope you found it useful. Thank you.